Yo. Always check description for more details. Examples of disputable presumptions, Bar 2011-2012. 1. Some significant disputable presumptions under Sec. 3 of Rule 131 are, a. That a person is innocent of a crime or wrong, b. That an unlawful act was done with unlawful intent, c. That a person intends the ordinary consequences of his voluntary act, Bar 2012. d. That a person takes ordinary care of his business, e. That evidence willfully suppressed would be adverse if produced, f. That money paid by one to another was due to the latter, g. That a thing delivered by one to another belonged to the latter, h. That an obligation delivered up to the debtor has been paid, i. That prior rents or installments had been paid when a receipt for the later ones is produced, j. That a person acting in a public office was regularly appointed or elected to it, k. That official duty has been regularly performed, Bar 2012, l. That a court, or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. Note, please refer to other disputable presumptions in Sec. 3 of Rule 131. 2. One of the most significant presumptions, which is, at the same time, a constitutional right, Sec. 14,121, Art. Ill. Bill of Rights, Constitution of the Philippines, is the right to be presumed innocent of a crime or wrong. 3. The constitutional presumption of innocence is enjoyed by the accused until final conviction and, in this regard, the prosecution's case must rise and fall on its own merits and cannot draw its strength from the weakness of the defense. People v. Mingming, 573 SCRA 509. The evidence of the prosecution must stand on its own strength and not rely on the weakness of the defense. People v. Bontuyan, Gr. No. 206,912, September 10, 2014. 4. The presumption that evidence, when willfully suppressed, would be adverse, if produced, does not apply if, a. The evidence is at the disposal of both parties, b. The suppression was not willful, c. It is merely corroborative or cumulative, and d. The suppression is covered by the privileged communication between physician and patient. Blue Cross Health Care, Inc., v. Olivares, 544 SCRA 580. 5. Generally, a notarized document carries the evidentiary weight conferred upon it with respect to its due execution, and documents acknowledged before a notary public have in their favor the presumption of regularity, which may only be rebutted by clear and convincing evidence. Rural Bank of Cabadbaran, Inc. v. Malesio Yap, Gr. No. 178,451, July 30, 2014. 6. The settled rule is that, in the absence of satisfactory explanation, one found in possession of and who used a forged document is the forger and therefore, guilty of falsification. If a person had in his possession a falsified document and he made use of it, uttered it, taking advantage of it and profiting thereby, the clear presumption is that he is the material author of the falsification. Maliwat v. Court of Appeals, 256 SCRA 718. The presumption, that whoever possesses or uses a spurious document as its forger, applies only in the absence of a satisfactory explanation. Metrobank v. Tobias Ill, 664 SCRA 165, 179-180, January 25, 2012. Hence, a satisfactory explanation would render the presumption ineffective. 7. A judgment or final order against a person, rendered by a tribunal of a foreign country with jurisdiction to render said judgment or final order, is presumptive evidence of a right as between the parties and their successors in interest. If the judgment or final order is upon a specific thing, said judgment or final order is conclusive upon the title to the thing. The presumptions are not, however, irrefutable. In either case, the judgment or final order may be repelled by any of the following: a. Want of jurisdiction, b. Want of notice to the party, c. Collusion, d. Fraud, or e. Clear mistake of law or fact. Sec. 48 Rule 39, Rules of Court. 8. While the judgment or final order rendered by a Philippine court, among others, in respect to the probate of a will or the administration of the estate of a deceased person is conclusive upon the will or administration, the probate of a will or granting letters of administration shall only be prima facie evidence of the death of the testator. Sec. 47 Rule 39, Rules of Court. 9. The persons mentioned in Art. 2180 of the Civil Code, like employers, and owners or managers of establishment, among others, are liable for the acts of those persons for whom they are responsible. Under the same provision, such responsibility shall cease when the persons mentioned prove that they observed all the diligence of a good father of a family to prevent damage. This indicates that there is a presumption that employers and other persons in art. 2180 have, likewise, been negligent in case those under them have caused damage to another. Whenever an employee's negligence causes damage or injury to another, there instantly arises a presumption juris tantum that the employer failed to exercise diligentissimi patris familias in the selection culpa elegiendo or supervision culpa invigilando of its employees. Macalinau v. Ong, 477 SCRA 740. 10. It is disputably presumed that a driver was negligent, if he had been found guilty of reckless driving or violating traffic regulations at least twice within the next preceding 2 months. Art. 2184, Civil Code of the Philippines. 11. There is prima facie presumption of negligence on the part of the defendant if the death or injury results from his possession of dangerous weapons or substances, such as firearms and poison, except when the possession or use thereof is indispensable in his occupation or business. Art. 2188, Civil Code of the Philippines. 12. In some cases where negligence is difficult to prove, the doctrine of res ipsa loquitur permits an inference of negligence on the part of the defendant where the thing or transaction speaks for itself. Josefa v. Manila Electric Company, Gr. No. 182705, July 18, 2014. The doctrine of res ipsa loquitur establishes a presumption of negligence against the defendant and furnishes a substitute for a specific proof of negligence. The doctrine can be invoked only when, under the circumstances, direct evidence is absent and not readily available. For the doctrine to apply, the following must be satisfactorily shown: a. The accident is of a kind which ordinarily does not occur in the absence of someone's negligence; b. It is caused by an instrumentality within the exclusive control of the defendant or defendants; and c. The possibility of contributing conduct which would make the plaintiff responsible is eliminated. Ramos v. Court of Appeals, 321 SCRA 584, Macalinau v. Ong, 477 SCRA 740, see Solidum 0. People, 192,123, March 10, 2014. 13. The legal presumption is that a person takes ordinary care of his concerns. To this, case law dictates that natural presumption is that one does not sign a document without first informing himself of its contents and consequences. Diaz v. People, Gr. No. 208,113, December 2, 2015. C. Quantum of evidence, weight and sufficiency of evidence. Proof beyond reasonable doubt. 1. In criminal cases, the burden of proof as to the guilt of the accused lies with the prosecution because of the presumption that the accused is presumed innocent until the contrary is proven. Sec. 14121, Art. 111, Bill of Rights, Philippine Constitution. Jurisprudence reiterates the above rule by declaring that in every criminal prosecution, the state must prove beyond reasonable doubt all the elements of the crime charged and the complicity or participation of the accused. People v. Maraorao, 674 SCRA 151, 159, June 20, 2012. See also People v. Roxas, Gr. No. 218,396, February 10, 2016. Proof beyond reasonable doubt is the degree of proof that, after investigation of the whole record, produces moral certainty in an unprejudiced mind of the accused's culpability. Atienza v. People, Gr. No. 188,694, February 12, 2014. Proof beyond reasonable doubt does not mean such a degree of proof that excludes all possibility of error. Only moral certainty is required. Sec. 2 Rule 133, Rules of Court. Sec. 2 of Rule 133 provides for the quantum of evidence required in criminal cases as follows. Sec. 2. Proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal, unless his guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such a degree of proof as, excluding possibility of error, produces absolute certainty. Moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. 2. The presumption of innocence of an accused in a criminal case is a basic constitutional principle fleshed out by procedural rules which place on the prosecution the burden of proving that the accused is guilty of the offense charged by proof beyond reasonable doubt. Corollary thereto, the evidence of the prosecution must stand on its own strength and not rely on the weakness of the evidence of the defense. People v. Bontuyan, Gr. No. 206912, September 10, 2014. Preponderance of Evidence, Bar 2003, 2011. 1. Sec. 1 of Rule 133 provides, Section 1. Preponderance of evidence, how determined. In civil cases, the party having the burden of proof must establish his case by a preponderance of evidence. In determining where the preponderance or superior weight of evidence on the issues involved lies, the court may consider all the facts and circumstances of the case, the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessarily with the greater number. 2. In civil cases, the party having the burden of proof must establish his case by a preponderance of evidence. Preponderance of evidence is the weight, credit, and value of the aggregate evidence on either side and is usually considered to be synonymous with the term greater weight of the evidence or greater weight of the credible evidence. Preponderance of evidence is a phrase which, in the last analysis, means probability of the truth. It is evidence which is more convincing to the court is worthier of belief than that which is offered in opposition thereto. Chua v. Westmont Bank 667 SCRA 56, 68, February 27, 2012. 3. Preponderance of evidence means that the evidence adduced by one side is, as a whole, superior to or has greater weight than that of the other. It is evidence which is more convincing to the court is worthy of belief than that which is offered in opposition thereto. BJDC Construction v. Lanuzzo, Gr. No. 161151, March 24, 2014. 4. In determining whether or not there is preponderance of evidence, the court may consider the following: a. All the facts and circumstances of the case, b. the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, c. the witness's interest or want of interest, and also their personal credibility so far as the same may ultimately appear in the trial, d. the number of witnesses, although it does mean that the preponderance is necessarily with the greater number. Sec. 1 Rule 133, Rules of Court. Substantial Evidence, Bar 2003, 2011. 1. The pertinent rule on substantial evidence is found in Sec. 5 of Rule 133. The relevant provision declares, Sec. 5. Substantial evidences, in cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusions. 2. Substantial evidence refers to such relevant evidence which a reasonable mind might accept as adequate to support a conclusion. Montanola v. Philippine Airlines, Gr. No. 198656 September 8. In administrative cases, the quantum of evidence required is that of substantial evidence. It does not require evidence that is overwhelming or even preponderant. Astorga and Ripoll Law Offices v. Villanueva, A.M. No. P09-2669, February 24, 2015. 3. In administrative or quasi-judicial proceedings, like those conducted before the NLRC, the standard of proof is substantial evidence which is understood to be more than just a scintilla or such amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Morales v. Harbor Center Port Terminal, Inc., 664 SCRA 110, 121, January 25, 2012. See also Republic v. Arias, Gr. No. 188909, September 17, 2014. In claims for workmen's compensation, for example, the degree of proof required is merely substantial evidence. This means that it suffices that the claims be based on mere probability, not certainty of causal relations. Leviste v. Social Security System, 539 SCRA 120. However, the employee has the burden to present substantial evidence or such relevant evidence which a reasonable mind might accept as adequate to justify a conclusion, showing a reasonable connection between the conditions of his work and his illness, or that the risk of contracting the same was increased by his working conditions. Masonke v. Trans Global Maritime Agency, Inc., 569 SCRA 5921. In agrarian cases, all that is required is mere substantial evidence. Heirs of E. B. Roxas, Inc. v. Tolentino, 167 SCRA 334. Quantum of evidence in a petition for a writ of amparo. In a petition for a writ of amparo, the parties shall establish their claims by substantial evidence. Sec. 17, the rule on the writ of amparo, effective October 24, 2007. Effect on the criminal case of failure to prove administrative liability. In Paredes v. Court of Appeals, 528 SCRA 577, the accused argued that as his liability in the administrative case against him was not established by substantial evidence, so will his criminal case necessarily fall, demanding as it does, a heavier quantum of proof, i.e., proof beyond reasonable doubt. To this argument the Supreme Court declared, "The petition must fail." It is indeed a fundamental principle, that administrative cases are independent from criminal actions for the same act or omission. Thus, an absolution from a criminal charge is not a bar to an administrative prosecution, or vice versa. One thing is administrative liability, quite another thing is the criminal liability for the same act. Criminal and administrative proceedings may involve similar operative facts, but each requires a different quantum of evidence. Thus considering the difference in the quantum of evidence, as well as the procedure followed and the sanctions imposed in criminal and administrative proceedings, the findings and conclusions in one should not necessarily be binding on the other. Notably, the evidence presented in the administrative case may not necessarily be the same evidence to be presented in the criminal cases. The prosecution is certainly not precluded from adducing additional evidence to discharge the burden of proof required in the criminal cases. Conversely, The Court Ha.S. also ruled that the dismissal of the criminal case is not per se a bar to administrative sanctions. To paraphrase, dismissal of the criminal case does not foreclose administrative action involving the same facts. Paredes v. Court of Appeals, 528 SCRA 577. Clear and convincing evidence, Bar 2011. 1. Evidence is clear and convincing if it produces in the mind of the trier of fact a firm belief or conviction as to allegations sought to be established. It is intermediate, being more than preponderance, but not to the extent of such certainty as is required beyond reasonable doubt as in criminal cases. Black's Law Dictionary, 5th ed., p. 227. 2. The Court, in Government of Hong Kong Special Administrative Region v. Olalia Jr., 521 SCRA 470, explained this quantum of evidence. Thus, an extradition proceeding being sui generis, the standard of proof required in granting or denying bail can neither be the proof beyond reasonable doubt in criminal cases nor the standard of proof of preponderance of evidence in civil cases. While administrative in character, the standard of substantial evidence used in administrative cases cannot likewise apply given the object of extradition law, which is to prevent the prospective extraditee from fleeing Philippine jurisdiction. In his separate opinion in Perganon, then Associate Justice, now Chief Justice Renato S. Puno, proposed that a new standard which he termed clear and convincing evidence should be used in granting bail in extradition cases. According to him, this standard should be lower than proof beyond reasonable doubt but higher than preponderance of evidence. The potential extraditee must prove by clear and convincing evidence that he is not a flight risk and will abide with all the orders and processes of the extradition court. 3. One recent case makes a more liberal use of the clear and convincing evidence rule when it declared, once an accused in a prosecution for murder or homicide admitted his infliction of the fatal injuries, he assumed the burden to prove by clear, satisfactory and convincing evidence the justifying circumstance that would avoid his criminal liability. People v. Fontanilla, 664 SCRA 150, 158, January 25, 2012, italics supplied. Evidentiary weight of electronic evidence. 1. In assessing the evidentiary weight of electronic evidence, certain factors may be considered, like, a. The reliability of the manner in which it was generated, stored or communicated, b. The reliability of the manner in which its originator was identified, c. The integrity of the information and communication system, d. The familiarity of the witness or the person who made the entry with the communication and information system, e. The nature and quality of the information which went into the communication and information system, and f. Other factors which the court may consider. Sec. 1 Rule 7, Rules on Electronic Evidence. 2. All matters relating to the admissibility and evidentiary weight of an electronic document may be established by an affidavit stating facts of direct personal knowledge of the affiant or based on authentic records. The affidavit must affirmatively show the competence of the affiant to testify on the matters contained therein. Sec. 1 Rule 9, Rules on Electronic Evidence. The affiant shall be made to affirm the contents of the affidavit in open court and may be cross-examined as a matter of right by the adverse party. Sec. 2 Rule 9, Rules on Electronic Evidence. End of Chapter 2. See you next slide. Thank you.